Yes, it says you're streaming live on YouTube now.
Okay. All right, so a number of things. We have some people present in the courtroom. We have some people present by via Zoom. I am in courtroom 8A at the Fulton County Courthouse. We have therefore satisfied our solemn obligation, which we take very seriously, to keep the public's business open and accessible to it. So obviously, you can come in person, come via Zoom, or you can attend via YouTube. Okay, there's a new person here. Apparently I admitted a new person. Okay, so at this point, I'm going to ask for some introductions. I'm going to address the issue of those attorneys who have asked to be admitted pro hoc. I am going to address who exactly at this point can participate insofar as putative interveners are concerned, and then we will get started. For purposes of courtroom security, I do not have a mask on, and I will state that I don't have a mask on because of my distance from everyone else, and I've also got some plexiglass in front of me. I have asked counsel to please continue to wear their masks. However, I do want people, when they are at the podium, free to remove them for purposes of argument. I don't know that we've finalized whether we need the microphone or not. If we do need the microphone, we try to make material present to wipe that off each time. So, Mr. Smith, we'll start with you.
Good morning, Your Honor. Ray Smith for the petitioner, along with Emily Denmark, my associate.
All right. Welcome, both. Thank you. And I think present on the Zoom website are your two clients, correct?
That's correct, Your Honor. Mr. Warren Schmitz and Dr. Jeffrey Kukas.
I'm sorry. Would you state your appearance again, please? I didn't hear you clearly.
Excuse me?
Would you state your appearance again?
Ray Smith for the petitioner, along with Emily Denmark for the petitioners. And then our clients are Warren Schmitz, who's by Zoom, as well as Dr. Jeffrey Kukas. Those are petitioners. Thank you.
Thank you. All right, counsel.
David Loman for respondent, Fulton County Board of Registration and Elections, Ralph Jones and Richard Barron. And with me, I have Kay Burwell. Your Honor, at 11 o'clock, Ms. Burwell needs to step out to participate in the hearing on another case, just so there'll be no interruption.
Okay, and who are y'all with the county attorney?
Yes, ma'am.
Okay, Mr. Loman and Ms. Burwell?
Yes.
Okay, thank you, welcome. All right, what lawyers do we have out here who are with either of these parties or have filed a motion to intervene?
Your Honor, this is Bill Custer. I'm with the Brian K. firm here in Atlanta. With me is my partner, Jennifer Dempsey. We also have co-counsel from the Lawyers Committee for Civil Rights, and that is Mr. John Powers and Ms. Julie Hauk. I also understand that appearing as well as Mr. John Greenbaum, who is the General Counsel of the Lawyers Committee for Civil Rights. Mr. Powers and Ms. Hauk have a motion to appear pro hoc vice before the court.
And Mr. Custer, who, assuming that we get to that, who will be speaking? And you are all the NAACP?
Yes, Your Honor. We represent both the NAACP and the Georgia Coalition for the People's Agenda. I will be addressing the motion to intervene, and should the court permit, Mr. Powers will be addressing the merits of the petition.
All right, we need to discuss the pro hoc admissions, but let me go ahead with some introductions here. Is there anyone on behalf of the people who filed yesterday?
Your Honor, Joyce Gist-Lewis from Crevlin and Horst here in Atlanta. How are you this morning?
Fine, thanks.
I am here with my associate, Adam Sparks, and also present is Amanda Calais from Perkins Coie. Ms. Calais has a Pro Hoc Vice application pending, and if permitted, she will be the person that will be arguing both the motion to intervene and the merits. And if not, we will address that eventuality once Your Honor rules.
Okay, New Georgia Project,
Yes, ma'am.
correct?
Yes,
Okay.
yes, Your Honor.
Are there any representatives of those organizations on the Zoom call in the nature of clients?
No, Your Honor.
Okay, and then I think we've gotten to every, all right, is everyone else who is on the Zoom call, and this is sort of a ridiculous way to ask this, but everyone else in the nature of an interested observer?
No, Your Honor. This is Ezra Rosenberg. I'm also an attorney with the Lawyers Committee for Civil Rights Under Law, representing the same potential interveners as Mr. Custer and Ms. Dempsey, Mr. Powers, and Ms. Hauk. And I understand that my Pro Hoc application is forthcoming.
Okay,
I'm speaking.
okay. All right. I'm going to start obviously with the petitioners, and I see Mr. Smith in just a moment. With regard to the Pro Hoc lawyers, again, before we get to the intervention question, I'm assuming petitioners oppose both motions to intervene.
Yes, Your Honor, we do. We think they're too late,
Okay.
amongst other reasons.
Okay. Assuming we get to those, then I guess Mr. Custer, let me just sort of start with you, and then I'll also ask Mr. Smith here in the courtroom. But my understanding of the Pro Hoc admission rules is that I need some sort of verification from the Georgia State Bar. Very good. Anybody want to speak to that?
Your Honor, we are checking to see if we have.
Okay, well, our staff attorney, Ms. Cummings, is also on the Zoom call. Do we have any letters from the State Bar or any type of indication from the State Bar that these have been even addressed?
No, and I will say that in the previous case where we had to get the Pro Hoc BJ clearance from the State Bar is not really providing it as fast. Now, they did go and ask them and make sure that they paid, because that's part of the problem, is that we don't know if the costs have been paid. And so that's normally why we wait to get the letter from the State Bar. So technically, yes, we can look at the motion, but with it being so late, it is kind of hard for us to be able to make sure that we had every I dotted and every T crossed. So
There is a Georgia lawyer for each of those parties, correct? Each of those interveners?
Yes, Your Honor, for NGP.
Okay, okay. All right, I'm going to hold off on that right now, and if there's nothing further, I'm going to go ahead and state for the record that this is a writ of mandamus action. That will figure into some of our substantive issues, but this has been filed by, on behalf of Mr. Schmitz and Dr. Kunkis by Mr. Smith, and I'll ask you if you'd like to proceed.
Yes, Your Honor.
Do you mind coming to the podium where you can remove your mask if you would like?
So would you like me to proceed on my motion itself and not talk about the motion to intervene?
I don't know. I'd like for you to proceed on.
All right. Good morning, Your Honor. I'm Ray Smith. As you know, I'm representing petitioners in this action. We are here pursuant to a Rule 9 that was entered on September 1st, as you know, for the relief sought petition for the writ of mandamus. As Your Honor is well aware, this is a very limited, and part of this also addresses some of the intervention, because this is a very limited question that's before Your Honor. This is a writ of mandamus. We are asking Fulton County Board of Elections to do what they're supposed to do under Georgia law. That's it. There are a lot of things that the interveners want to do that other think that they have other rights and remedies that they can address to the Fulton County Board of Elections, to other remedies. But this is simply my folks wanting the Fulton County Election Board to do what the Georgia law says they're supposed to do. My clients filed a petition on August 13th, 2020, seeking this writ of mandamus. The writ of mandamus under Georgia law, as Your Honor is well aware, says all official duties shall be faithfully performed, and whenever from any cause a defect of legal justice would ensue, from a failure to perform or from improper performance, a writ of mandamus may issue to compel a due performance if there is no other specific legal remedy for the legal rights. And that's 9-6-20 under the Georgia Code. As to my client's burden of proof to obtain the writ, the code provides, quote, where the question is one of public right and the object is to procure the enforcement of a public duty, no legal or special interest need be shown, but it shall be sufficient that a plaintiff is interested in having the laws executed and the duty in question enforced. And that is 9-6-24. As I said, my clients are two individuals residing and are registered to vote in Fulton County, as I am myself, Your Honor. And in fact, I served on the County Board of Elections myself.
Excuse me. I'm sorry, I missed something. You said residing in a registered.
In Fulton County. I myself am a registered voter in Fulton County, and also myself served on the Fulton County Election Board for 1.5 years, a number of years ago. So I'm well aware of what the duties and obligations of the Fulton County Election Board are. The board is an entity in Fulton County designated to supervise primaries and elections and is responsible for the registration of electors of Fulton County under OCGA 21-2-40. As part of its duties regarding the registration of electors of Fulton County, the board is required to consider and rule upon any challenges regarding the qualifications and right of an individual to vote in the county. Specifically, OCGA 21-2-229 provides in pertinent part under subsection A, any elector of a county may challenge the qualifications of any elector of the county whose name appears on the list of electors. Such challenges shall be in writing and shall specify distinctly the grounds of the challenge. B, upon such challenge being filed with the Board of Registrars, the registrar shall set a hearing on such challenge. Notice of the date, time, and place of the hearing shall be served upon the person whose qualifications are being challenged, along with a copy of such challenge. The statute then goes on to set forth the hearing requirements for a challenge to the voter qualifications, and that's 21-2-229. In addition to being charged with considering challenges to the qualifications of an individual to vote in Fulton County, the board is also tasked with considering the challenge to the rights of persons to vote in Fulton County. And this is the other code section that we cited. Specifically, 21-2-230 provides in pertinent part under subsection A, any elector of the county may challenge the right of any other elector of the county whose name appears in the list of electors to vote in an election. Such challenge shall be in writing and specify distinctly the grounds of such challenge. Subsection B says, upon the filing of such challenge, the Board of Registrars shall immediately consider such challenge and determine whether probable cause exists to sustain such challenge. And Your Honor, we submitted a list of some 15,000 folks in Fulton County in about 6 House districts in Fulton County that have either moved, no longer reside at these locations, have died, or have moved, or what have you, in these districts. We have boxes and boxes of affidavits in my office from either the people who now live in these residences, from apartment managers, or from the voters themselves who say they no longer live at these locations.
Yeah, let me interrupt for just a minute. I don't want to knock you off.
Right.
This is the first time I'm hearing about died.
Yes,
I think your letters all referred to change of address.
right.
Because one question I was going to ask you was, could we agree that 232 isn't really the applicable provision?
Well, there are two sections, Your Honor, 229 and 230. There's no
Right.
232.
One of your letters talked about 232, so I just looked into it and I just wanted to make sure that I don't have to uncover that too.
Right, no, there's 2 sections, 229 and 230.
Right.
Right.
Are we talking about voters who have died?
There are some, yes, that have died.
Did you make the board aware of that?
Yes, Your Honor, we did.
Did you mention that in your writ? Your petition for writ?
It was in the demand letters, yes, Your Honor.
Okay, because I tried to look at all that pretty carefully, and I
Right.
thought everything was changed of address.
Right. Then like sections,
But you're saying no, but you told them in your letters.
yes, Your
that-
Honor, we did. Like section 21-2-229, section 230 goes on to set forth the requirements regarding notice of the challenge and the consequences of the board's determining that probable cause exists in support of the challenge. 21-2-230. These code sections are part of the election code, which begins at 21-2-1. Here, the petitioners provide notice to the board of the challenges as to qualifications and the rights of some of these almost 15,000 individuals who are registered to vote in Fulton County but no longer reside in Fulton County or are deceased. In fact, petitioners provided 5 notices to the board of the challenges, and those were exhibits A through C, E, and G in our writ, Your Honor. The board has refused to set the statutorily required hearing to immediately consider petitioner challenge and thus have failed to comply with its duties under 229 and 230. That failure is why the petition was filed. The first letter we sent was on July 8th, 2020, requesting the board to review and consider removing those individuals. The second one, and remember, now this is not to say you got to remove these. This is to follow the procedure under the code to set a hearing date to allow these individuals to then send a notice and have a hearing for the county board to have a hearing, Your Honor. We're just asking to start the process, okay? That they have the right to do that because somebody has not come forward and said and done their duty to remove these people or to transfer their voter. Some of these people, we've got affidavits that they moved out of state. They're no longer even in Georgia, Your Honor. Let me use my own situation. My daughter died a year and a half ago. We got, when the Secretary of State sent out the mass mailing back when the COVID first hit, I got a notice that my daughter was still registered to vote in Fulton County. I did because my wife and I did not want anybody voting for her. We did what the Secretary of State said. We sent in our notice to the county or to the state with a death certificate, Your Honor, to take her off the voter registration list. Most people aren't that conscientious, but we did it.
We're asking the court and the county to do what the law says, Your Honor. We're not trying to take anybody's voting rights away. We're trying to clean up the voter record so that on November 3rd, we can have, Your Honor, a legitimate vote. Because, Your Honor, if any of these House districts, or if the 6th congressional district, if any of them are close and there is a challenge, they're setting it up to have a legitimate challenge to that election. And we're trying to tell Fulton County, don't let that happen. Because it's hard enough to challenge a vote, an election, because you've only got 7 days from the day that the vote is certified to challenge that election, Your Honor. Make it clean now. Don't wait. So we sent in that first challenge.
Now, let me ask you this again, I hate to interrupt, but we're acknowledging then that with regard to the election, well, the election tomorrow and the election on November the 3rd,
Right.
and we're talking about federal offices.
Correct.
Okay.
Federal and state, Your Honor.
But they include federal.
Right, yes, Your Honor.
Okay, so I'm sure you're gonna get to it, but just when you can, 20507, if you would just address that, because it seems to specifically address federal.
Yes, I'm getting to that. Your Honor.
Okay.
Yes, thank you. So anyway, so we had our first challenge. They didn't respond. Second challenge, July 16, 2020. They didn't respond. Third challenge.
I'm sorry, Counselor, repeat that again, the first one?
The first challenge was July 8, 2020. No response. Second challenge, July 16, 2020. There was no response. Third challenge, July 24, 2020. The board finally sent a response on July 28th. They said that they believe that a hearing was unnecessary, even though the law says it's mandatory. They're supposed to set a hearing date. And it says that it was removed. It was prohibited because of, as Your Honor cited, the federal code, and I will get into that. The fourth challenge was July 29th. Again, noted the board's statutory duty to hold a hearing under 229 requested a hearing. Then the county attorney's office filed a response July 31st, which I'll refer to as the second board's response. And they again cited the U.S. Code 20507D. And again, I will get to that in just a few minutes after I get through the background here. They said the board would respond to the list of challenge voters at the time, but they would not do it until January of 2021. So because the second board response again failed to set a hearing date and failed to comply with the requirements of the Georgia Code, and our fifth challenge dated August 7th was sent to the board requesting an immediate hearing under 229 and 230. We challenged the board both qualifications and the rights of these voters. Again, the side note, the fifth challenge was directed to the Fulton County Attorney's Office, was also sent to the board. Of course, no hearing was set by the board to consider the petitioner's challenge, and thus the petition for the writ was filed. In their petition, my clients requested the court to direct the board to do three things. Immediately set a hearing under 229 and 230. Number two, provide the statutorily required notices of petitioner challenges and the resulting hearings to the challenge voters. And number three, determine the qualifications and rights of the challenged electors to cast their votes in Fulton County elections. The petitioners also, we also sought attorney's fees for failing to do that. In a case such as this one, Your Honor, where a public official has failed to perform his official duty, it's appropriate for this court to issue a writ of mandamus to mandate performance. The Court of Appeals has recently provided that the writ of mandamus is a remedy for improper government inaction or the failure of a public official to perform a clear legal duty. The writ of mandamus is properly issued only if, one, no other adequate legal remedy is available to effectuate the relief sought, and number two, the applicant has a clear legal right to such relief. And that was in the Love versus Fulton County Board of Tax Assessors case, which is cited in our brief. A clear legal right to relief exists where the claimant seeks to compel the performance of public duty that an official or agency is required by law to perform. The duty must be clear and well defined. Whether a litigant has a clear legal right to relief sought in a mandamus petition depends on the law governing the subject matter at issue, which in this case is 229 and 230, which I've already discussed. The Court of Appeals has specifically stated that mandamus is a proper remedy when the governmental board fails to conduct a hearing as required by law. And that's the Quarters Decatur case versus the City of Decatur, Your Honor. And that's cited in our brief.
I'm sorry, that was Decatur. Say that again.
The Quarters Decatur case versus the City of Decatur.
Quarters?
Quarters, like a quarter, like a spinning a quarter.
Okay.
The petitioners have demonstrated that they are entitled to the writ of mandamus they seek because, as the verified petitioners set forth, number one, they submitted the challenges to the board under 229 and 230. Those code sections permit the petitioners to challenge the rights and qualifications of anyone on the Fulton County voter list to vote. And those code sections also require the board, upon written notice of a challenge, either to set a hearing on the challenge under 229 or to immediately consider such challenge and determine whether probable cause exists to sustain such a challenge under 230. The board thus has a statutorily mandated duty to immediately hold a hearing and otherwise consider the challenges in order to rule upon them. The board has refused to comply with its requirements under 229 and 230 since July, Your Honor, of this year. The petitioners have no other specific legal remedy for the board's failure to perform its public and statutory duties. The petition for writ thus concerns a question of public right. The object is to procure the enforcement of a legal duty. And the petitioners are interested in having the code executed and the board duties enforced under 9620 and 9624. The petitioners are aware of the burden of the board is under during a federal and presidential election year. However, the burden does not excuse the board from complying with its statutory duties. Let me go down and address the issue about the federal, if you will. Their primary argument in support of their, and they've addressed this in a motion to dismiss, is it barred because of the NDRA. Where Congress has expressed its intent for federal laws or regulations, that federal law should preempt state law. Any state law that conflicts with the federal law is without effect. Federal law may preempt state law by one, express preemption, number two, field preemption, regulating the field so extensively that Congress clearly intends that subject area to be controlled only by federal law, or three, implied or conflict preemption. And that's the Georgian versus the Carr case. We've cited that. It's a Georgia appeals case. Implied or conflict preemption.
Sorry, it's the Georgia what case?
Duren, D-U-R-E-N versus Pacar, P-A-C-C-R-A-R case. It's a Georgia appeals case. Implied or conflict preemption is where the state and federal law actually conflict, so that it is impossible to comply with both or state law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. The respondents have relied on this NDRA, and that section 1 states, a state shall not remove the name of a registrant from the official list of eligible voters in elections for federal office on the ground that the registrant has changed residence unless the registrant A, confirms in writing that the registrant has changed residence to a place outside the registrar's jurisdiction in which the registrar is registered, or B, has failed to respond to a notice prescribed in paragraph to and has not voted or appeared to vote in an election during the period beginning on the date of the notice and ending on the date after the date of the second general election for federal office that occurs after the date of the notice. The Georgia Election Code contains 3 sections, Your Honor, mirroring the provision of NVRA. That's 233, 234, and 235 of 21-2-233, 34, and 35. Section 234 specifically addresses removing individuals from the voter list who haven't voted in the last 3 years and safeguards the board must undertake to ensure eligible voters aren't removed from the voter roll. So by arguing that Section 8 of the NVRA preempts Georgia 229, the respondents are also arguing that 229 and 234 of the same Georgia law, Georgia.
I'm sorry, could you slow it down just a little bit?
I'm sorry. So by arguing that Section 8 of the NVRA preempts Section 229, the respondents are also arguing that Sections 229 and 234 of the same Georgia law, the Georgia Election Code, are directly in conflict. But the respondents haven't provided any consideration of this issue. Also, Sections 233 and 234 both provide, Your Honor, quote, nothing in this code section shall prevent the removal from the list of electors of an elector for ineligibility to vote. And that's OCGA section 21-2-233E and OCGA section 21-2-234H. But again, the respondents haven't considered those provisions or provided any analysis for their implications on the Georgia Code of the NVRA. The portion of the Georgia Code mirroring the NVRA is separate from the portion setting forth the challenge procedures under which petitioners submitted their challenges to the board. Coming back to the preemption analysis, Your Honor, it is true that the United States Constitution vests in its states the authority to regulate federal elections, but reserves to Congress the prerogative to alter the state's procedures. And that's the Belito versus Snipes case, and that's Belito, Bellitto versus Snipes case, and that's an 11th Circuit 2019 case, and that's cited in our brief. In Belito, the 11th Circuit analyzed Section 8A of the NVRA and first noted that the NVRA has twin objectives and that there is some tension between those objectives. The twin objectives are, on the one hand, easing barriers to registration and voting, while on the other hand, protecting electoral integrity and the maintenance of accurate voter rolls.
Say it again, while on the other hand?
On the other hand, protecting electoral integrity and the maintenance of accurate voter rolls. Preventing the states from removing registrants from voter rolls altogether would ensure that no eligible voters are removed, but at the same time, maximize the risk associated with inaccurate voter rolls. Thus, Congress drafted Section 8A of the NVRA, which addresses the state's administration of the voter registration list to ensure that any eligible voter is registered to vote in an election. And that's the Project Vote Inc. versus Kemp case. And that was a Northern District of Georgia case back in 2016. In analyzing Section 8A, the 11th Circuit noted, quote, the law permits the states to remove registrants only under defined circumstances, including because of death or change of residence, but it also requires the states to conduct a general program that makes a reasonable effort to remove the names of voters who have become ineligible on account of death or change of address, which is exactly what we have here, Your Honor. And that's in the Belito. That's an 11th Circuit case. Here, 229 does not conflict with 8A of the NVRA, and thus the NVRA does not preempt the section of the Georgia Election Code. While the NVRA provides a safe harbor process for the list of maintenance activities, courts have acknowledged that the NVRA requirements for the safe harbor provision we're discussing do not prevent the removal of names from the official list of voters of persons who are ineligible to vote. For example, the Sixth Circuit Court of Appeals has stated, quote, In creating a list of jurisdictions for removal, Congress did not intend to bar the removal of names from the list of persons who are ineligible and improperly registered to vote in the first place. The NVRA protects only eligible voters from unauthorized removal. Bell versus Marinko case is what we cited, and that's a Sixth Circuit case from 2004. Marinko, M-A-R-I-N-K-O. In Bell, the Sixth Circuit considered whether the Ohio Board of Elections violated the NVRA when it removed voters from the voter roll in responses to challenges brought under Ohio state law. The court determined that based on the board's investigation of those challenges, the board found that the challenged voters weren't residents of that precinct, and thus they were improperly registered to vote, so that the voter roll was inaccurate. The court stated, quote, as instructed by the NVRA, the board necessarily removed their voters from the rolls. We were to find that the board's removal of these voters does not violate the act. We would effectively grant and then protect the franchise of persons not eligible to vote. Because the act does not bar the board's continuing consideration of the voter's residence, and instead encourages the board to maintain accurate and reliable voting rolls, we find that the board's procedures in this case do not contravene the NVRA. If we were to interpret the NVRA as the respondents do, then the board would be required to keep voters on the voter roll, even if they are no longer eligible to vote in Fulton County, simply to meet the requirements of the NVRA. But the NVRA requirements apply to a state's general voter list maintenance and do not apply to prevent the board from removing ineligible voters from the roll. The respondents are incorrect that 229 is in conflict with the NVRA because, number one, the board's obligation is to ensure the voter roll is accurate, is separate from the list maintenance procedure of the NVRA. And number two, the NVRA doesn't prevent the board from removing ineligible voters from the voter roll. There is no presumption here, Your Honor. So the respondents haven't shown that it would be futile to require the board to consider the challenges because the NVRA would prevent voters from being removed from the roll if the board concluded that those voters were ineligible. Thus, the respondents, we believe, do not have an argument in that request. So, Your Honor, we would move that Your Honor grant our motion, and I'll reserve remainder of my time for any rebuttal.
Before you sit down, Mr. Smith, now help me understand one thing, because I may just be completely missing it, and it may not matter.
Okay.
But I am puzzled, I guess, by the issue of there being deceased people that you brought to the board's attention. Because just in reviewing your letters in preparation for today and in reviewing your writ, and specifically on page 2 in paragraph 4, petitioners filed with the board their challenge to the qualifications and right of 14,346 individuals on the list of Fulton County's electors to vote based on said individuals' residencies. So I looked back through the letters and I'm just seeing that it was the evidence that you said you presented. Well, just reading from your July 16th letter, which is Exhibit B to the complaint or the petition, 366 voters admitted not living in Fulton County or voter acknowledged registering to vote elsewhere. 141 current resident of voters registration acknowledged that the voter does not live at the address registered. 54, leasing manager of the apartment complex acknowledged the voter does not live at the address registered. 245, proof of registration in another jurisdiction, and then 13,542 people who are exact matches per the National Change of Address database. And obviously the reason that I ask is because 229, No, what you're calling section 8, and I hope to understand that better, but 20507 talks about addresses.
Right.
So I just help me. Is there, today you said, you stood in your place,
Right.
and you said, no, we told them about David.
I believe in my first letter, Your Honor, I did mention the July 8th letter, I believe I did mention that there were, because I do know for a fact that there were some dead people that were listed in the group of 14,000. Now, whether or not it was in the petition, if Your Honor says it's not there, then it's not there. I'm not going to dispute that.
No, I'm just curious because it just brings into play another section of Georgia law.
Right.
And you're arguing that the national voter,
But Your Honor,
URBA doesn't preempt these other code sections, and I'm just in Georgia code sections.
Right.
I'm just trying to ensure that those other Georgia code sections are in play.
Right. Well, Your Honor, I mean, the bottom line is we're really not here today to argue the substance
Right?
of why these people should be removed from that's for once the county does what the law says they're supposed to do, then that's what the county's supposed to do. What we're here today to do is ask the court to tell the county to do what the law says to do, which is to have a hearing or to consider these petitions. That's all we're asking the court to do. We're just giving this as background.
But the defense, among other things, is the writ of mandamus would not lie to force a futile act.
I'm sorry, Judge, I didn't get the last portion.
The
Writ of mandamus would not.
would not lie to enforce a futile act.
Right. Well, we don't think it's futile, Your Honor. We've got all these affidavits of people who, a lot of them are people who actually live in these houses or in these apartments who say, or these apartment managers who say, these people don't live here anymore. We don't know where they live, but they don't live here anymore.
But can the Board of Electors or Board of Elections remove those people now
They can't.
in federal elections?
No, what they're supposed to do is, Your Honor, is they're supposed to then investigate themselves. They're supposed to send out a letter and say, hey, there's been a challenge. There's going to be a hearing. This is what you're supposed to do. They're supposed to investigate under 229. They're supposed to send out a letter, and then they're supposed to have a hearing. Under 230, they're supposed to see whether it's probable cause to remove them from that's all they're supposed to do. That's all we're asking the court to do, because we're going to present them with these boxes. I've got 5 bankers boxes of affidavits in my office, Your Honor, right now, and I'm supposed to get more of these, and we are going to present them to Fulton County if the Board of Elections does what we believe the law says they're supposed to do. And then they're supposed to then take those and do what they're supposed to do.
So maybe here's a better question. Does section 20507D is that the exclusive way to have people removed for change of address, change of residence?
Well, Your Honor, we
In
believe
federal elections.
we believe that the federal and the state work together. That you can that it doesn't, as I said, the federal does not stop the state from keeping its records clean and keeping its voter lists clean so that you can have a fair election.
Common Cause Indiana, Common Cause New York. I mean, I guess what I'm asking you is 20507D states what must be done to remove a resident, or to remove a voter for change of residence. And is that the exclusive in a federal election? Is that the exclusive way to do it.
No, Your Honor,
Remedy, but way to do it.
we don't believe that it is. Thank you.
Thank you, Mr. Smith.
Thank you.
Mr. Smith, well, let's get back to the intervention issue. I will hear from you.
Okay, thank you.
Thank you. All right, Mr. Lemon, if you want to take a second and just take that light out, because I'm sure Mr. Smith is just fine.
Please court. Petitioners are asking the Fulton County Board of Registration and Election to remove 14,346 voters in rolls because they allegedly meet the statutory required.
Okay, I'm having difficulty hearing you.
Sorry, is that better?
Yes, that's better.
They are here seeking a writ of mandamus, directing respondents to set a hearing for the Board of Registration and Elections to determine these petitioners' challenges prior to the November elections. However, federal law bars such an action, and we ask this court to dismiss the petition for the following reasons. First, petitioners do not meet the standard and are not entitled to a writ of mandamus in this case. Federal law bars respondents from removing the challenged voters in the time frame sought by petitioners. And even if the hearings were held and every single challenge was upheld, no voters could be removed until after January 5th, 2021 election. Therefore, in the interest of governmental and judicial economy, we ask that this writ be denied. Now, the standard for mandamus is when a petitioner has a clear right to the release sought and when there has been a gross abuse of discretion. And in this case, as we will demonstrate, petitioners possess no clear legal right to such relief. And furthermore, petitioners have not made a single allegation of gross abuse by any of the respondents. Now, the relief sought in this case, and it might have changed in the last bit of exchange between Your Honor and petitioner's counsel. But up until that point, it was to hold a hearing and to remove these voters and have this done before November election. Because in the respondent's response letter, and we'll get to that in a minute, it was explained.
I'm sorry, respondent's letter. I didn't hear that after.
The respondent's letter, it was explained that no action could be taken on any of these hearings or any of these challenges until after January of 2021, and it would be taken up at that time. So if it is now the position that all they want is for the respondents to begin researching and reviewing, and they understand that no one can be removed, then we don't really have that much of an argument because we understand that these need to be reviewed and researched, and the board has the discretion to do that. However, nobody can be removed. Okay, so here we are. The relief that's being sought is to have the hearing before November in which these voters' challenges are heard, and if upheld, these people are removed from the rolls.
And Mr. Smith may well be asking the court to do that, but I didn't hear him say it needed to be before November 3rd. And if he's asking, I mean, he'll tell us if that's what he's asking, but I didn't hear that it had to be done before November 3rd.
Well, and that is why we are here asking for the writ to be denied if that's the case. So I guess we can find out. Now, federal law prohibits the board from removing any of these voters because we got federal elections. We've had a federal election tomorrow, got one in November, got one in January. And as Your Honor has pointed out, 52 U.S.C. 20507C keeps us from removing.
I'm sorry, 520?
20507C prohibits anyone from being removed within 90 days of a federal election. And we are clearly there. So the relief being sought is just to have a hearing and to have these people's challenges heard and to have them removed, then there's no clear relief because we can't do that. Secondly, there's been no gross abuse of discretion on the part of the board. The board responded to Mr. Smith's letters, explained the situation, explained that they would assign someone to review the list, to figure out what needed to be done, but at this time, they cannot act upon it for several factors. One, we are in the middle of several election cycles. Staff availability is limited, and that was explained in the letter to Mr. Smith. Secondly, we are in a pandemic, and so staffing and work from home and virtual, it doesn't work for the board to be able to do this at this time. So the board has the discretion to put forth manpower for something that is a worthwhile activity, which is something that is futile, and in this case, running elections, which is by absentee, by early, and by election day voting, is precedent, takes precedence.
But that's not addressed in 229. Code section 229 doesn't say you shall hold the hearing, you shall hold the hearing only if you have the appropriate staff to do it.
Correct.
For enough time.
And they didn't say that they wouldn't have the hearing, Your Honor. They said they will have the hearing and they have the discretion to decide when to have the hearing. So in this case.
Well, let's just say, I mean, I think we can agree that there's no time limit in 229.
Correct.
As to when the hearing.
Correct.
Shall be.
So there is no time limit. So the board responded. They didn't ignore Mr. Smith's pleas and they didn't ignore his letters. They explained the situation. They responded back to him and he filed this action here today. Now, the discretionary act involved in this is when to set the hearing, if probable cause is present, and the board gets to decide that. The letters.
230?
Yes. So.
Is 230 first? I mean, are you suggesting that first we look at everything and we decide whether there's probable cause? Then we go back to 229 and schedule a hearing?
I'm sorry, Judge, you said then we what?
Do you first go to 230 and decide probable cause and then go back to 229 and say, okay, now we're going to have a hearing?
I'm not exactly sure. It's not prescribed in that manner, but in this case, with the 14,000, the list, it was decided, take a look at it and see. And once it was determined that it was all based on national change of address, then there was nothing further that could be done at this time. However, it's not as if these challenges won't be heard, they just will not be heard on the time frame that the petitioners have sought in this case.
Well, then let me interrupt you and ask you the same question I asked Mr. Smith. For change of address for residents, which brings up another whole issue about where you intend to reside, but is 20507D, is that the exclusive way to exclude voters who have changed residences in a federal election.
Is the understanding that unless the person has notified the Board of Registration and Elections, then yes, that would be the specific way to do that.
That would be what?
You're saying there is a situation, and Mr. Smith alluded to one very sadly, but if there is a situation where someone comes forward and says, by the way, I no longer live here and I have registered somewhere else, then 20507 lets you take them off.
Correct. Now, let's say for a moment that the judge orders these hearings to take place prior to November 3rd, 2020. What must be done is all 14,000 plus people must be given notice. A hearing must be set. And what this hearing would be is, it wouldn't be one hearing, it'd be several. It would be 14,000 plus people getting notice of a hearing date that will call for a special call meeting of the Board of Registration and Elections. Now, to do that in this pandemic environment, we would have to have a quorum for several days. Your Honor, I believe the last time a mass challenge like this occurred was approximately 200 people in December of 2015, and those hearings took at least one day. So we're talking about a sustained quorum of the Fulton County Board of Registration and Elections for several days. And logistically, would that be virtual? Would you force people to come in during this state of emergency? Would you have to make arrangements for people who did not have access and cannot attend virtually? What would you do? So say we figured all of this out and we held the hearing for days and days on end. And as Mr. Smith said, he brought in his banker's boxes and we brought in everybody and we got in the room, and this was before November, and everybody got everything done. Well, what happens then? Nobody can still be removed until after January 2021. We still can't remove those people because the National Voter Registration Act says can't remove those people. Can't remove them 90 days before federal election. We can't remove them until 2 federal election cycles thereafter given notice. So we can't do that. So if we're here today and the board is forced to do it, there's nothing that can be done other than what we said we would do in the first place, which is after the second federal election cycle, it will be taken up and then the challenges will be heard and the board will do their duty at that time. If you have no questions, I'll come back.
Well, yeah, I do, just a couple of things. And this is very much for the purposes of argument, very much for the purposes of argument. This is no telegraphing, but what is the difference between a dismissal and a denial?
Dismissal, I guess it depends on whether it's with or without prejudice. Just dismiss.
I'm sorry?
Do you mind saying it one more time?
Dismissal is with prejudice is the sit. It depends on whether the dismissal is with or without prejudice. So if it's dismissed with prejudice and you've heard the merits, then that's it.
Okay. There is something in, and I will confess, and you can address this, Mr. Smith, I may have read this in an interviewer's brief, so I can't point to the specifics, but there's something in response to the writ to the effect that the evidence itself was not formally presented. Does the county rely on that?
Well, it's my understanding that to the extent that the county has any information, that they began to review it. And I believe that if there are people who are
deceased, and that was made aware. When we were made aware of that, we would have checked with the Office of Vital Records to try to get that part taken care of, because that would require a hearing, obviously.
Okay.
But I'm not sure what the amount of the information that was provided to the county. And that is one of the reasons why we moved for continuance, because our people who are conducting an election today and tomorrow could testify to that. However, you know, they're not here, they weren't required to be here, so I don't know. I haven't seen any of the evidence, I haven't seen any list, banker's boxes, or anything.
Okay, thank you. All right, so we now have the question of, I'm certainly inviting Mr. Smith to respond to that. You want to go ahead and respond, Mr. Smith, and then we'll talk about intervention. Just put a light on that real quick.
Okay.
Thanks.
You're on a couple things. We did in the first letter that we presented to the county, we did provide a complete list of the 14,000, almost 15,000 people by house district, name, address, et cetera. And evidence was provided to the county. In fact, in one of the letters back to us, I don't remember which in the chain, they said that they were going to provide a person in the county to start looking into it. But that's not what the code says they're supposed to do. That's not the procedure that the code says. It says they shall provide a hearing under 229. That's why we kept pushing, because we wanted them to follow the law, what they were supposed to do. And Your Honor, as Your Honor pointed out, we did not ask per se that it be done before November 3rd. In fact, 230 says, let me point to, if you read it, 230 permits a challenge to be made at any time prior to the elector whose right to vote is being challenged, voting at the elector's polling place. And for absentee ballots, the statute provides for the challenge to be submitted to the board and further requires the hearing to be held, quote, on an expedited basis prior to certification of the consolidated returns of the election by the election superintendent. So it's possible, especially with the number of absentee ballots that are going to be presented this time, that we could be challenging, there could be a challenge to absentee ballots after November 3rd, under 230. So, and let me also correct.
But we agree, I don't have that in front of me.
Right, no, I understand. Yes, you're right. I just wanted to correct that for the record. Also, council talked about the standard, and I wanted to correct. The dispositive question for this court is whether the allegations of the mandamus petition construed most favorably to petitioners disclose with certainty that petitioners could not show that they have a right to relief and no other adequate legal remedy to obtain it. And again, that's the Porter case that we cited earlier. As I've already discussed, the allegations in the verified petition plainly state a claim for relief. That is the issuance of a mandamus petition directing the board to fulfill its official non-discretionary duties under 229 and 230. I will also say that their motion to dismiss had nothing to do with 230, it's only 229. The respondents incorrectly assert that the appropriate standard here is whether the board abused its discretion by completely failing to hold a hearing and otherwise properly consider the petitioner's challenge. That's not the correct standard, Your Honor, because the abuse of discretion test applies only when the official duty at issue is discretionary, not mandatory as it is here, Your Honor, as set forth in 229 and 230, excuse me. None of the cases cited or relied upon by the respondents in their brief involves a mandatory duty. They cite the Carnes case. In the Carnes case, the duty at issue was the county's closing of a public road, and under the county ordinance, that decision was discretionary.
In the Doherty County case, Your Honor, that they cite, the issue was the issuance of a special variance under a zoning ordinance. Again, the ordinance was discretionary. And finally, in the Tamaroff case, that's TAMARROFF case.
Spell it again, please.
I'm sorry, TAMAROFF case. The petitioner sought a mandamus writ directing a judge to appoint them as special process servers. However, the statute outlines the appointment as discretionary. Thus, none of these cases cited by the respondents, Your Honor, regarding the appropriate standard for relief apply to the instant case where the official duty here is mandatory.
Well, they mentioned gross abuse. So is there a nuance between mandatory, not doing something mandatory, and a gross abuse?
I don't know, Your Honor. I mean, there's nothing listed, Your Honor.
Okay.
So,
Let me ask you a question, Mr. Smith.
yes, Your Honor.
Let's say I enter an order that says the respondents are to conduct a hearing on December 1st, 2020 for the first 500 names. On January the 2nd, they're supposed to hold a hearing on the second 500 names. And I do it every month until 14,000 runs out.
Until
14,000 runs out. I'm sorry, Samantha. And in the first 500 on December the 1st, they find clearly 40 people who have left the state. And they're looking for the rolls.
I believe they can, Your Honor.
How?
Under the code, they can do that, Your Honor. Because if they follow the procedure, they are doing. Now, if they show up at the polls, at that poll and say, I want to vote, and I still live here, or I still live in this district, they can give them a provisional ballot. They can't stop them from voting.
Okay. And just again, totally for argument purposes, is there a difference between denial and dismissal?
Well, it depends on if it's with or without prejudice, Your Honor.
Okay.
Thank you.
Thank you. All right, well, we now have the issue of interveners, and at this point, and there's been certainly a good bit submitted in terms of paperwork and certainly in terms of time and effort on the part of both potential interveners. I think NAACP, just by virtue of this court's intention very intentionally, to present us with a reasonable time frame. And I mean, I really wanted to make sure we did that. If this were to be a mandamus that was granted, we certainly, time was of the essence. And so does anybody have really the time to sit back and read everything and intervene? And Mr. Smith, if you don't mind, and I don't want to open a can of worms, but do you think NAACP is untimely?
Yes, Your Honor. We believe both of the groups are untimely. The Supreme Court has held that under the Bullitt County case, that untimely motion must be denied where a hearing the case has been set. It's very technical. In that case, Your Honor, the summary judgment motion was set for November 14th. The motion to intervene was filed on November 8th, 6 days earlier.
The Supreme Court affirmed the trial court's denial of the motion to intervene because it was untimely. OCGA 9-11-6D requires the written motions must be served not later than 5 days before the time specified for the hearing, and 3 extra days are added to the mailing rule. Because the motion to intervene wasn't filed outside of the 8-day period before the summary judgment hearing, it was untimely and had to be denied. The court even went as far as to say, quote, in view of the provisions that the 3 additional days shall be added, it cannot be held as a matter of law that no harmful error is shown by the fact that the plaintiff was able to file pleadings in opposition to the motion prior to the date specified for the hearing. Following the Bullitt County Bank holding in a different case, the Georgia Court of Appeals held that a motion to intervene should be denied when it's untimely. There, the party seeking to intervene presented its motion to the court on the day of the hearing, and that was the Osteen versus General Electric case. That's Osteen, O-S-T-E-E-N. Even if you look at the motion to intervene from a practical standpoint, it's untimely. The petitioners gave notice of their first challenge to the board on July 8, 2020. Now, almost 3 months later, the movements argue their motion is timely because the petition was filed on August 13th, barely over a month ago. A hearing has yet to be held, and they were prepared to be here today, is what they said. What they don't say is when they first learned about the challenges, or even this lawsuit, Your Honor. It seems like the movements have known about this lawsuit for a while because they found the time to hire local counsel plus 3 attorneys from Washington, D.C., and they're here today with a motion to intervene, propose an answer, propose the motion to dismiss, and they got 2 affidavits, Your Honor. They've also known about this lawsuit long enough, Your Honor, according to the movements, to start diverting their resources to try to obtain the list of challenged voters and start educating them about voter caging and about steps they can take to prevent their voter registration status and cast a ballot that will count in the upcoming election. That's right from their motion to intervene on page 9. Given the length of time that the petitioners have been trying to secure the respondents' compliance with their statutory duties under 229 and 230, Your Honor, and given the time it must have taken for the movements to prepare to apply to intervene, it seems like the movements have chosen to come to the table at the 11th hour, and Georgia law does not apply that, does not like that, Your Honor. The motion to intervene should be denied because it's untimely. Georgia law provides the movements cannot intervene here where they have a remedy that can be asserted in a proper proceeding. Quote, if the one who seeks to intervene will still be left with the right to pursue his own independent remedy against the parties, regardless of the outcome of the pending case, then he has no interest that needs protecting by intervention and should not be allowed to intervene over objection. The movements must have shown that they have, quote, no other remedy to protect their interest. And that's the Potters, P-O-T-T-E-R-S, Props LLC case versus VNS Court case.
Spell that again. Verse.
VNS Court, like Victor, Nancy, Scott Court. Here, the movements can present their concerns to the board. The eligible voters may not be able to vote as a result of petitioner challenge after the board actually sets a hearing on the challenges or considers them. Intervention in this matter before this court, which only involves a mandamus petition. Your Honor, as you know, the mandamus is a very limited remedy, and it's against a governmental entity. It's not these other. This is not joint tort feasors or others that have. They may have some rights at other preventions and other venues, but not at this point. They can file a separate action under NVRA against the board if they believe the board is taking some action in reviewing the voter rolls to prevent eligible voters from voting. They have done this very thing. In fact, there was an article in the AJC, if Your Honor may have seen it a couple weeks ago, with the DeKalb County, where the election boards in federal court, where they claimed that under the NVRA, the board should be prevented from removing eligible voters from the voting roll. Because the movements clearly have other remedies to address these concerns they raise in the motion to intervene, they should not be allowed to intervene in this matter, which only involves a petition for writ of mandamus. Georgia law also provides the movements from intervening in this action and then expanding the scope of the litigation to address these concerns. Quote, a true intervener takes the case as he finds it and cannot expand the litigation. He or she merely stakes a claim to a share in the result of the pending litigation. And that's end of quote. And that's the O'Brien versus Builders insurance case that we've cited in our brief. The movements have a long list of concerns, Your Honor, about voter education, voters' rights, but none of these issues, Your Honor, are before the court regarding our petition for mandamus. Based on the facts that the movements want to address their concerns in this matter, it's clear that the movements are trying to expand this litigation far beyond what a writ should do to direct the board to perform the statutorily mandated duties they're required to do. It simply doesn't make sense to allow the movements to intervene here. The petitioners are seeking mandamus relief, which is properly issued against a government official. Here, the movements can't provide the relief sought by the petitioners, and they haven't shown the necessary stake in this outcome of this case to be allowed to intervene. But more importantly, Your Honor, you can't rush in at the last minute and ride in and try to get involved in the lawsuit. Thank you.
Thank you. All right, well, in view of that argument, I'm going to let the following people speak to just the issue of timeliness and intervention. Mr. Custer, I will hear from you, or I'll hear from Mr. Custer or Ms. Dempsey, and I will hear from Ms. Just Lewis Sparks.
Your Honor, may it please the court. Ms. Bill Custer. I'm here with Jennifer Dempsey today.
And I hate to interrupt you, but this is limited to the issue of timeliness and the motion to intervene.
I understand, Your Honor. And I'll limit my remarks to that. Obviously, we filed a brief and we think we've covered the legal issues. So I won't rehash everything we've said in our brief and we'll stand on that, the brief. But let me address timing. This proceeding is really very, very young. As we understand it, it was not filed until August 13th, and none of these demand letters nor the petition were, of course, filed on our client. We found out about, that is, our clients found out about these proceedings in the second week of September, which was really just a short time ago. And since that time, our clients have moved, we would suggest, with alarming speed to address these issues. We still have not seen a complete list of all the voters that are being challenged. We only got a list of the voters just last week. We're still in the process of trying to determine whether those voters actually implicate some of our members, and we don't even have information sufficient to make that determination. Nonetheless, our clients moved through their organizational processes to get approval to intervene. They have hired counsel, they've conducted an investigation, and within 2 weeks, on the 23rd of this month, they filed a very detailed petition. And of course, we can't just intervene with a perfunctory filing. We had to investigate, and we had to prepare all of the documents necessary to intervene. And we would submit, we did so in a very reasonable, if not on an emergent basis. They've raised the question of whether OCGA 911-6D prohibits the court from allowing our intervention. Of course, it does not. There is a 5-day rule, but this court is within its discretion to shorten that period for emergency circumstances like this. If this case had been pending for several months and we had been on notice of it for several months, he might have a very different argument. But the argument here that us learning of it and getting our filings in within 2 weeks, I don't think makes the same case as was made in the earlier cases he cited. We do not have a remedy, another remedy, an effective remedy. As we understand the petition, they are requesting that the Fulton County government proceed with efforts to remove these individuals. In fact, this proceeding is an effort to begin the process of removing these voters from the rolls. And that's in direct contravention of the NVRA. Of course, the court has looked at 52 USC 205.7, but I want you to look in particular at the language in Section C 2A, which says a state.
Excuse me, Your Honor, he's getting into substance, and that's not what Your Honor asked.
Actually, go ahead and respond to that.
And I just want to make this very quick point, Your Honor, that the state must complete its proceedings to remove voters 90 days before the election. And thus, even this proceeding is within those 90 days. And so
I'm going to sustain Mr. Smith's objection. I think that's outside the scope that I said.
And Your Honor, I do want to address his last point, which is that we somehow want to expand these. We do not. We want to address the specifics of the petition and why the relief sought in the petition is in violation of the NVRA. That is the limit of our purpose for intervening in order to protect the organizational interest of our clients and perhaps their members. As I say, we do not yet know whether our members are directly implicated by the petition or not, because we have not seen all of the documents that have been discussed here today. And so for all of those reasons, and for the reasons set forth in our written materials, we would urge the court to permit intervention, either as a matter of right or either under Section B, which is permissive intervention.
Thank you. Ms. Just Lewis, is this going to be you?
This is going to be Mr. Sparks, Your Honor.
Well, hang on. Is Mr. Sparks one of the pro hoc?
No, he is a Georgia lawyer, Your Honor. He's an associate member.
Alice is a.
It's me, Your Honor. Adam Sparks of Crevlin and Horse. The new
I got that wrong. Sorry.
No, that's quite all right.
I'll write down. I'll correct my notes. Go ahead.
Yes, Your Honor. And I will do my level best to stay within Your Honor's scope of discussing only timeliness and intervention. The New Georgia Project's right for intervention under 911-24A and alternatively permissive intervention under 24B. We join the arguments of Mr. Custer, except that ours are taken to an exponential degree. Our client only had actual notice of this action this past Thursday. That's when the New Georgia Project discovered certainly the scope of 15,000 voters that were being challenged through this petition. For background, the New Georgia Project's reason for being is registering all eligible voters of color in Georgia and encouraging them to turn out and participate in elections. They've actually registered north of 75,000 voters in Fulton County, and we also have not seen the entire list. It is not public, and certainly the letters that are exhibits to the petition were not sent to our client either. So between the lack of public information, the lateness of the actual notice, and I would just direct Your Honor to page 6 of our memorandum in support of the New Georgia Project's motion for intervention. Footnote 1 invokes Kroger v. Taylor, which commits the decision on a motion to intervention to Your Honor's discretion and notes that, forgive me for reading, but this is important for the record, where intervention appears before final judgment, where the rights of the intervening parties have not been protected, and where the denial of intervention would dispose of the intervening party's cause of action, intervention should be allowed, and the failure to do so amounts to an abuse of discretion. Now, without expanding beyond the boundaries set by Your Honor, let me submit that the New Georgia Project's interest in this case is extremely strong, and the granting of such a petition would be quite dire, both to its constituents' right to vote, and there are a number of defenses that we're happy to get into in terms of substance, but also to the mission and the operation of the New Georgia project. Such a grant would cause extreme harm to its ability to carry out its mission this close to an election. With that, I'll rest on our briefs because I believe it's addressed the timeliness issue, but I'm happy to answer any questions as well.
Okay, thank you very much. Yes.
Your Honor, just a few points, please. First of all, again, the timeliness is very technical, Your Honor. The Bullitt case could not be more clear. The Georgia project just filed their brief yesterday. And a lot of the issues that are raised by both Mr. Custer and the Georgia project's attorney are issues that will be before the Fulton County Board of Elections if the writ was granted by this court and it were to go and have a hearing or probable cause under 230. That's not what's before this court, Your Honor. All those issues they raise are not before this court. That's not what we're here for. We're here just to decide, Your Honor's just here to decide whether or not my folks get we move to the next stage and we get a hearing, or they decide there's probable cause to move forward. That's where they get to move and say all their things and bring all their evidence, and they can examine our affidavits and they can examine our petition further and that kind of thing. That's what this is all about, Your Honor. They try to muddle what is a very straightforward petition. The NVRA prohibits the purge of thousands of Georgia voters from voting rolls. They further point to their efforts to encourage voter participation in the November 2020 election and beyond, and their fear of having to divert considerable resources to educate and assist impacted Fulton County voters to make sure they are not purged from the voter rolls. Movements refer to the federal and constitutional rights. Petitioners allege direct attack on and attempt to undo and neutralize the good work of movements. Petitioners allege attempt to compel the board to violate its duties and purge voters from the rolls. Respondents' inability to adequately represent the interests of all Fulton County citizens and the board's possible disincentive to zealously represent the interests of movements. We're not doing any of that. They're just muddling the waters, Your Honor. This is why they shouldn't be able to intervene. This is not what we're doing here. Your Honor, not only are they not timely, but that's not what we're here to do. Thank you.
Thank you. All right. I'd like to first point out that the writ of mandamus is an extraordinary remedy. You know that. And it is governed by statute in this particular case. The time limits or the time specified by the court, again, was specifically geared to the urgency of the question raised by the petitioners. And therefore, this court tried to move as fast as it could. So maybe I put everybody on the back foot. But I felt that it was such that it was important to move forward. I am going to grant the county's motion to dismiss. I am granting it without prejudice. And I'm granting the county's motion to dismiss for a number of reasons. But I want to go ahead and do this now. I want to get it on the record because I want you to seek any rights you may have to appeal. First of all, there is no time limitation in what I'm going to call Section 229, which is specifically 21-2-229. So I think it fails. First of all, the writ fails on that basis. This question of whether there is a clear duty, I don't believe that either of the letters from the county said we're never going to do it. I also don't think there's any dispute as to facts in this case. And so from the standpoint of interpreting or considering everything in the petitioner's favor, the court has done that. Secondly, I think 20507 of the federal NVRA applies. These are federal elections that we're talking about, and I believe there is an issue of preemption in this case. Mandamus number 3 by statute 9-6-26 will not be granted when it is manifest that the writ would for any cause be nugatory or fruitless. So again, I go back to my question to Mr. Smith about if we had a hearing tomorrow and all these people were found ineligible, could they be stricken from the roll? So I believe that granting the writ in this case would violate 9-6-26, and it would be a fruitless act. And 4, I am dismissing this writ for any other reason applicable under Georgia law. I therefore find that the motions to intervene are moot. The court will not grant those. All right, Mr. Lohman. Okay. Mr. Lohman, can you prepare an order?
Yes, Your Honor.
And will you, I didn't realize that everybody's busy, but will you send that to Mr. Smith? And then if you'll send it into the court, I'd like to get it entered as soon as possible. And again, wish you luck on your road
Thank you.
after this. All right, anything further?
I think that's it. Thank you, Your Honor.
Okay.
Thank you.
Thank you, everybody, for their time.
Thank you, Your Honor.
Your
Thank
Honor.
you, Your Honor.